Welcome to this explainer. If you are a focused learner looking to master the foundations of life insurance law, you're in exactly the right place. Today, we're unpacking Chapter 1 of the LLQP Manual, which is all about the legal framework governing life insurance. I like to think of this legal framework as the rules of the game. Because let's face it, you can't play the game or properly project your clients if you don't understand the board you're playing on, the pieces you can move, and the rules dictating every single play. Okay, let's dive into this.
Here's our roadmap for today. We're going to hit 5 key areas: the insurance legal framework, players in the agency relationship, legal status and capacity, estates, wills and successions, and finally, torts and void contracts.
Starting off with Section 1, the insurance legal framework. Let's establish the literal game board we're playing on here, the insurance contract itself. Before we get into agents or beneficiaries, we have to know what this legal document actually does in the eyes of the law. At its core, an insurance contract is a formal, legal undertaking. It's an agreement by one person, the insurer, to indemnify another person against loss or liability for a specific risk. Or, as is super common in life insurance, it's an undertaking to pay a specific sum of money upon a certain event happening. It's basically a financial safety net carved into legal stone.
Moving on to Section 2, players in the agency relationship.
Now that we've got our board, let's introduce the players. In common law, the relationship between an insurance company and the person actually selling the policies is highly specific. The delegation of authority is called agency, and the folks holding that authority are the agents. The organization handing out that authority, they're known as the principal. The principal controls the extent of the delegation, which usually takes one of two forms. Now, what's really interesting about this slide is the clear legal boundary between the two types. We've got independent agents who act on behalf of multiple insurance companies, offering a whole variety of products. Contrast that with career agents, who act primarily for just one specific company. But regardless of which path an agent takes, the exact terms and limits of their authority are strictly laid out in the written contract they sign with the insurer.
But agents and insurers rarely just work in a vacuum. A lot of times there is an absolutely crucial middle player, the managing general agent, or MGA. MGAs act as the ultimate facilitators. They're in the trenches supporting agents with getting those insurer contracts. They process and track the business submitted by agents, provide direct sales support, and basically act as a vital communication bridge. They facilitate the entire two-way flow of information between the insurer and the agent.
Up next is Section 3, legal status and capacity.
To even participate in an insurance contract, to actually play this game, we need to know who is legally capable of doing so. The law is incredibly specific about who, or what, possesses legal capacity. We've got 3 main buckets here, and this brilliantly illustrates how the law treats these entities completely differently. First are natural persons. That's you, me, everyday human beings. Next, we have partnerships, which are business arrangements between individuals. And finally, we have legal persons, which are corporations. A corporation is treated by the law as a distinct legal entity, entirely separate from the natural persons who own or run it. Knowing exactly which entity you're contracting with dictates the entirely different sets of legal rules that are going to apply.
Which brings us to Section 4, estates, wills, and successions.
We've covered the players and the entities, but what actually happens to these contracts when tragedy strikes? This is where the dry legal definitions of Chapter 1 suddenly get incredibly human. Let's look at a very specific scenario straight from the text. Imagine a mother, Magda, and her son, Peter. Peter's staying over at Magda's house. In the middle of the night, a tragic furnace malfunction fills the entire house with carbon monoxide. The next morning, sadly, both Peter and Magda are found to have passed away in their respective beds. Now, Peter and his sister were joint beneficiaries of Magda's life insurance policy. So here's the critical legal question I want you to think about. If 2 joint beneficiaries die in the exact same accident, who legally gets the insurance money? Does Peter's half go to his estate, or does something else happen entirely?
The answer comes down to survivorship rules. See, the law cannot just guess. It relies on medical testimony and hard evidence to determine the exact order of death. In this specific case, the judge concluded that Peter, who was a smoker with respiratory problems, breathed more rapidly and likely died first. Because Peter officially predeceased his mother, his sister inherited Magda's entire death benefit. If Peter had outlived his mother by literally just a few minutes, he would have been entitled to his half share, which would have then been routed right through his own estate. It's just a striking example of why precision in the law matters so incredibly much.
Let's head into our final section, Section 5, torts and void contracts.
Let's look at the dark side of the board for a minute.
These are the special rules that can completely invalidate the game. To understand void contracts, the manual gives us this wonderfully bizarre case study. Meet Ralph. Ralph is an arsonist who wanted to collect fire insurance money on a commercial property. So Ralph finds a criminal and literally pays him $10,000 to burn the property down. But there's a huge twist. The criminal takes Ralph's 10 grand and promptly gambles it all away without ever lighting a single match.
Naturally, Ralph is furious. He made a deal. He paid the money up front, and the service was not rendered. So I pose this question to you. Can Ralph actually take this criminal to court? Can he sue to get his $10,000 back? Does a contract for an illegal act hold up in front of a judge?
So the crucial point is, absolutely not. No way. The contract was completely unenforceable from the very beginning. The law views this as a void contract because it is fundamentally against public policy. You just cannot use the legal framework to enforce an illegal act. Ralph is out his 10 grand and he has absolutely zero legal recourse.
And that naturally brings us to our final legal concept for today, the tort. A tort is defined as an action, or sometimes a failure to act, an omission, that causes someone loss or harm, making the wrongdoer legally liable. Essentially, it's a non-contractual civil wrong. If you harm someone outside the bounds of a written agreement, tort law is the framework that holds you accountable. It really rounds out the foundational knowledge every agent needs to operate safely and, frankly, ethically.
We've covered the contracts, the agents, the entities, the heartbreaking tragedies of estates, and the strict boundaries of legal and illegal acts. These aren't just abstract concepts to cram for a licensing exam. They are the literal rules that dictate how wealth is protected and transferred in our society. So I leave you with this final thought. When you look at your own insurance policies, or when you are advising a client on theirs, do you truly understand the legal rules of the game governing those financial safety nets? Keep diving into Chapter 1. Keep studying the framework, because understanding the rules is the only way to win the game for your clients. Thanks for joining me on this explainer.